Actually did not hear back, did not get a document back in a form that I could do. I got it back in a PDF, couldn't manipulate the PDF, so had to make the change based on the discussion. That's why it's dated about a month after, or a couple weeks after. I didn't have it in a form that I could manipulate, at that time. That's why.
As far as the map, that's another concern I have. There was a copy in that copy that you gave me, Doug, thank you. It's so tiny and so unclear that I can't decipher it or interpret it, so I don't know how you can use this to set the parameters and how it will be enforced, because it's not real clear and it needs to be clear. I questioned my property quite some time ago and had issue with it, how it was owned or whatever, and wanted to discuss it, and that sort of fell by the wayside, never got done. The issue, one of the other issues that was brought up that nothing was done about was about the decimal levels, about the noise, okay? You have a member of your board of the planning commission, not the supervisor, that is an expert in his field. It's an audiologist, Jeff Dittmer, that said that the decibel levels are unreasonable. You had members of the audience that had meters on their phone that just me speaking exceeds those decibel levels. Jeff said those are not reasonable. There was discussion, and Doug, correct me if I'm wrong, please, but you asked Mr. Dittmer if he would be willing to meet with you guys to give his expert testimony or expert opinion and form that and come to a fair and reasonable conclusion on what it should be. No acknowledgement, no answer, I get that. That was said and done, you asked him that, and that meeting never took place. There was never any further discussion on it. Lee, when I asked him if he read it, and he said that he had not, his reasoning for that was he said he didn't have to because he had his experts in their field on the board with them that he relied upon, namely Jerry Zwicker in land design, Jeff Dittmer, audiologist, Jody Noble, township manager and well experienced. Yet those three experts that he relied on all voted no. All voted not to pass it. Jody Noble's reasoning was it was an incomplete document, or she used another word. What's that?
Dead document.
Dead, that the next board was just going to throw it out anyway. So he said he relies on those experts, but yet they told him to vote no. He voted against those experts. So that doesn't make a lot of sense. There's several things, as I point out, that were discussed in meetings, changes that were to be made. And Kathy Gilmore's proposed motion that got changed several times or amended to get it right at that time, I believe, and Kathy, please correct me if I'm wrong, but he voted on, I believe it was the April 3rd version, and amended your motion to include all the changes that were discussed, all the notes, all the changes up to that time. Is that not correct? Okay, thank you very much. That was not done. There was stuff that was discussed that was not in that, and there was stuff that was not discussed that is in there. Namely, some of the changes you just referred to about the setbacks, and the 400 feet setback on compressor stations and stuff, and the 80 acres. Okay, there was discussion on those aspects, but not that specifically. So there was changes made that were not discussed at the Planning Commission before they voted to send it forward. So there was stuff that was put in that wasn't discussed, and there was stuff that was discussed that was supposed to be put in that was not. Fair to say? There's definitions that still have not been clarified that are hugely important, namely the definition of ag production, which you started to touch on. That's what the majority of this community is. This stuff, again, you've heard me say it before, it needs to be crystal clear. Do it right or don't do it. Because if you don't, it can and will be applied executively, judicially, administratively, as needed at the time. It can be and it will be. You know, we shouldn't have to keep going back to court for this stuff. If we'd followed through, continued on the path that we were on, with you working with everybody, to make it the best it can be, iron it out as we go. Those first, what was it, 33 pages, 34 pages? We got through, everything's good to go. If we would have just continued through, and now there's what, 84? So, another 50 pages, we would have been done by now. You would have had it through, there would have been nothing to argue about. Medical marijuana, that is still an issue as far as, because it says, it needs to be allowed in all zones to be consistent with industry, and that is not how it is. It is not allowed in all the zones, but it is supposed to be consistent with industry, and it's not. I'm not in the medical marijuana business, nor do I care to be. But if somebody comes in here and you want to protect, the welfare includes legal action, lawsuits. This township, you keep saying, doesn't have the money, but we're leaving ourselves open. We're spending a lot of money on legal costs, and we're leaving ourselves open for litigation. If you get somebody, a company that wants to come in, like Jack Ham is doing that big, what, 31 acre, where's that at? You know what I'm talking about. Say they want to come in and you don't have it right, guess what? Like Eddie said, they're going to do what they want to do. They have the power and the money to take us to court and stomp on us and do what they want to do. And it's just going to cost us money and harm. So there is, that was a question, Michael, you had for Miss Tammy today. Irreparable harm, or what's the correct terminology?
Immediate or irreparable?
Okay. Your question was tactfully stated. And as far as the Donegal Freedom Group, no, we don't have anything before board because we are strictly an association to represent all the citizens of Donegal Township, to help them. So anybody that has anything before the board, that would be the case. You know what I mean? Any permits, anything out there, you know what I mean? So no, the Donegal Freedom Group doesn't have anything out there, but some of its members may, some of the citizens may. Your licensing and permitting language and the, for lack of a better term, enforcement officials is sort of gray and not clarified. There's different terminology for the same meaning. That was something that we were discussing and working on clarifying. Never got done. Adult-oriented establishments. Definition refers to Chapter 5 of the Donegal Township Code. Once this is in place, that code goes away. So then it's another question mark and another gray area. It's not defined. So you're proposing moving forward with an incomplete document that is going to cause more problems than it's going to solve. If you stayed the course, done it right, and did it right the first time before you implement it, that would avoid all that. Section 303.26, similar uses, was another thing that was added without discussion. It's another one of those to go to the list. Almost done. And Leah, I'm sorry, I don't mean to pick on you. I can't fathom being in that position. I recall that meeting, and it was a 3-3 vote. And you said, I guess it falls on me, I'm the deciding vote. But you admitted you hadn't read it, but you're the one that made the deciding vote to send it forward. But that is not right. It's just not. Not right. In anybody's book, that shouldn't be right. At the very least, anybody that hadn't read it on any of the boards, Dave, you as chairman of the supervisor, Lee, you as chairman of the planning commission, or anybody else that hadn't read it should have to abstain from the vote. Because what right do any of you have to impose anything? You guys want to talk about us as a Association and Freedom Group, what right do you guys have to impose anybody on any of the citizens of Donegal Township that you haven't read yourself? That is the government, in its smallest sense, in the local government, saying, do as I say, not as I do. That's wrong. And last but not least, as Tammy stated, this is not over. This is ongoing litigation. There is a court hearing set for December 20th, okay? That this will get played out. I would recommend, I would most importantly ask Mr. Crooney, as the level-headed, common sense head up on that, sitting at that table, that you recommend to your board that they table this and take no action, just like they did the other night on a building permit, to table it and take no action pending further legal advice, opinion, and I think a judge sort of supersedes an attorney. So it still will go in front of that. This might be all for nothing. Why waste more taxpayers' time and money when it ain't over till it's over, and it certainly isn't over till December 20th. So I would appeal to you three, and especially you, Michael, to inform them, advise them that way, that take no action and table this till after the hearing on December 20th. Thank you.
Yeah. I don't really have much to say, but JD wanted to go last, and I'm not giving him the last word.
Sorry.
I wanted to ask you guys to seriously search your hearts. There's been a lot of bad blood in 2 years. And you've successfully spent all the money now. So I think you could probably buy a little bit of goodwill just by not doing it. And like Mike said, you do still have to live in this community.
Thank you. Any further questions, comments?
Right, one other thing. I do have a comment. One, Mike Smith has already said, we're gonna rip this out and do away with it. Okay? We're gonna do away with it. So if this group is so intent on ensuring that this is the perfect zoning ordinance, why, it's just what Mike said, it's an ongoing, living, changeable document. Why is it that you as a group wouldn't go ahead and let this go and make the changes that you want to make, which don't take that much effort, because you already know what you want to change. So the truth is, you just don't want zoning regardless. Regardless.
Can I answer that?
Okay? No,
You guys
just a
allow-
minute.
Okay, when you're done. I'm
I
sorry.
didn't ask you a question.
I
made
wasn't
a
talking to
comment.
you. I was talking to them. I apologize.
Okay.
I wasn't addressing you.
And inevitably, every one of you come here with that agenda right from the get-go, right from the beginning.
Sure.
And it's because Daddy didn't want it, Mama didn't want it, 20 years ago we didn't have it. Nothing's ever going to change in this township, and we represent everyone. No, you don't. You don't represent me.
Just the majority,
You don't
just the
represent-
silent majority.
No, you do not. No, you do not. The silent majority simply doesn't come out because they don't want to get into it with you.
They don't vote either, apparently.
Well, apparently they don't. You are correct. You are correct.
Well, a silent majority is no majority at all.
That's all. I'm sorry.
That's okay. Thank you. State your name for the.
My name's Bob Wright. I'm from Dry Ridge Road, Donegal Township. And the Freedom Group doesn't completely speak for me, but neither do you in saying that you know that we come in here, Most of you are lumping me with the Freedom Group. You don't know what I think. I've never told you what I think about this. You think about that because I have never said, no, do away with zoning. Thank you.
Respectfully answer Kathy's statement. Yes, a silent majority is no majority at all. And the people did speak overwhelmingly, 81% to 19%. So that is a majority. At least where I went to school, that's the math. It isn't about, the reason why they said that, we were working with the board, as I stated, you probably weren't listening, and making it the best it could be. We said we would help. We came, Michael and I were here before anybody was, working with them, trying to make it the best it could be. And that's why I said the dynamics changed. They decided to discontinue working with the public, to discontinue trying to make it the best it could be, and just put through an incomplete document. Had they continued on that path, we still would have been working with them to make it the best it could be. But when you ram something down somebody's throat and it's not right and not just and not complete, then naturally they're gonna throw it out. And I can say that because I'm not gonna be a supervisor. That's all.
Michael,
Okay.
yeah, I have something further, just to rebut something that was said earlier without getting in a big argument. This board never was forced to send this back to the planning commission. That is incorrect. The fact is, the board formed a planning committee as per the MPC. There was some discussion or argument on whether or not creating a planning committee of the board had to be done by ordinance or could be done by motion because the supervisor has done it by motion. The supervisors, rather than fight that battle in court, we said, well, we'll just send it back to the planning commission, make it a lot simpler, a lot easier, a lot less costly, rather than fight the battle, be fighting the battle of whether or not we formed a planning committee correctly. Is that not correct? Is that what not happened?
Yes.
And
We
Michael, I
never, the
believe
judge
that's
never
exactly what I
ordered
stated.
us, never ordered this
Oh, my
board
God.
to go back and do it again at that point. That never happened.
There was a consent motion.
We agreed to go back and do it a different way.
Correct.
We were not told to go back and do it a different way. We said it would shortcut the process, be a lot less expensive. But we weren't told, nobody questioned the validity of how we formed the planning committee until the board was ready to take a vote and have a public hearing on the proposal, which had worked on almost a year. At that point, it's questioned, they look for every little item, said you didn't follow this regulation, didn't follow that regulation. And so we tried in our earnest to follow the regulations, follow the laws. From the get, you can laugh all you want, but that's what happened, okay? And, it was an honest effort. And we invited the community to come, we invited the people, some of these folks, both sides of the aisle, were here meeting after meeting for months and months. And, but, at some point during that time period, the copy of their own correspondence surfaced that they were deliberately, where they admitted to deliberately trying to stall the project. And that went on, and every turn, there was a stall tactic. That's what caused things to turn the corner.
Thank you. Anything further than this?
Let's move on to the hearing.
So my recommendation now would be that we close the hearing.
Before we do that, Michael, I'd like to make one comment to Mike Smith. Mike, in your comments, you made the statement that the three of us up here at this table had been rude and obnoxious to you and other people in this room. I would challenge you to cite one instance where I personally have ever been rude or obnoxious to you or anybody else in this room.
Sitting there letting it happen is the same thing.
No, it's not.
Not speaking and not standing up and not saying. is
I
the
have
same thing.
spoken when I thought it was necessary, but you tell me one time that I have been rude or obnoxious to you or anybody else in this room. You can't do it because it hasn't happened. Anybody disagree with me? Have I been rude or obnoxious to anybody here?
Yeah.
No, I haven't. You tell me when.
Well, the last supervisors meeting, you were kind of rude and obnoxious.
You want to give me specifics?
We're here about zoning, remember?
You can't give me specifics, can you? I've never been rude to you or
I
anybody else
believe,
in
yeah,
here.
yeah, you were rather rude and obnoxious in some of your seconds and your comments and the way you conduct yourself. I would disagree with you,
You
yes.
can't give me a specific.
Every single time when one of them have looked at us and said, hey, let's move on, and you immediately jump on everybody, let's move on, shut them up. Yes.
I've never said that.
Yes, you have, Zach.
All right, we can agree to disagree on that.
Motion to close the hearing.
Okay, yeah, I'd make a motion that, you adjourn the hearing, close the hearing tonight and, take it under advisement. And at a future date, you can decide whether or not you want to amend, adopt, reject, et cetera.
I was gonna ask the question, what's the next step in this process?
The next step in the process would be, under the NPC, they have a few different items they can do. They can, at a later date, they can hold another hearing. They can send it back to the planning commission. They could advertise to adopt it. They could do nothing with it. There's a handful of matters for them to decide upon. And that would be up to them, ultimately, what they decide. But my recommendation is not to take any action at this hearing, but at a later date, they can go ahead and set a time frame if they should so choose to. The NPC sets forth, depending on what they decide to do, sets forth of what they have, what would then come about.
Would that later date be after the 20th, would be your recommendation, or not?
What's that, after the hearing?
After the hearing. I mean, it is a scheduled hearing. It is
Yeah,
gonna
no,
happen.
I understand that. My recommendation would be that any action taken prior to that would be subject to the court's, possible, whatever
It
the
would
court
cost
may
more
decide.
money for the township if they did it now, instead of
It
waiting.
could possibly, I'm not
Could
sure.
Well,
possibly,
even to advertise it would cost unnecessary money if,
which we do all the time.
We have a motion on the floor, Michael.
To adjourn?
No, the motion to close the hearing and take under advisement.
Okay.
Is that your motion?
Yes,
Any questions?
you didn't have a second though.
I'll second. Are there any questions? How you vote?
Mr. Ely?
Yes.
Yes, Mr. Prescott?
Yes.
I'd like to move that we adjourn the public hearing at 7:30. 5-minute break, and then we can commence the special meeting. 7:35.
Any questions? How you vote?
Mr. Ely?
Yes.
I vote yes. Ms. Prescott?
Yes.
Motion's carried.